For consumers, you need to know what an EUO is. An EUO is an examination under oath. Now, for 2 years in Tallahassee, Florida, what I've heard from your legislators are that this is just a nice little interview with the insurance company. The insurance company is just going to ask you some routine questions and then pay your claim. In the words of Joe Biden, that's a bunch of malarkey. An examination under oath is a deposition. You are going to be thoroughly interrogated about your entire life, your sex life, your work history, criminal history if any, your marriage, and then maybe they'll get around to talking about this accident and the treatment that you've had. I've been in EUOs that go on for days. I've been in EUOs that go on for hours. This is not a friendly, tell us about your claim so we can pay. This is, we're going to interrogate the heck out of you to find any way not to pay your claim. The biggest change in the new PIP law with regards to EUOs is that now, as a condition preceding to receiving any coverage, you must give them. What does that fancy lawyer mumbo-jumbo mean? It means this. If you are asked by your insurance company to give an EUO, you have an absolute obligation to do the same, or the insurance company does not pay any of your claim. Let's talk about the conundrum of problems this is going to cause, both for doctors and for consumers. Picture this. You could be treating for your accident, not even have a lawsuit. You treated, you got your treatment, your bills were paid. 6 months, 9 months, a year later, the insurance company says, you know what? We want an examination under oath from you, Mr. and Mrs. So-and-so. And you say, why do I have to go? My treatment's over. I did everything, they paid. Well, your doctor and you are going to get a bill, and it's going to be give us all our money back because you didn't comply with your insurance policy and we have no obligation to pay. And what the legislature did a very poor job of was making clear that that situation can never occur. Secondly, as a consumer, if you are bringing a PIP claim, you should expect an EUO. The legislature just gave the insurance industry carte blanche permission to do EUOs in each and every one of these claims, and they will. Why? They're digging. They're digging for any way, either in your medical history or your personal background, to not pay $1 on your claim, or, in the alternative, to only pay 25%, the $2,500, versus the full amount of the claim, the $10,000. You need to recognize if you, as an accident victim, are getting a letter or getting a call from your attorney saying that you need to be at an EUO, you need to be there. Secondly, if you don't have an attorney, you best give one. Because like I said, this is not going to be a day at the beach. This is not going to be some friendly exchange. This is a deposition, and you are going to be thoroughly deposed, and the insurance company is looking for a way to not pay you a dime. Lastly, for doctors, if your patients are talking about examinations under oath, you need to make sure they're going. Under the old law, the only thing an insurance company could do if you didn't show for this examination is void coverage, and that's coverage going forward. Now, there's never coverage, and that's a big and dramatic change. You need to make sure you know what an examination is. You need to make sure you have professional and thorough preparation for the same by an experienced accident attorney who's handled these things, and you need to be prepared for the same the minute your claim begins. Let me also tell you about IMEs. An IME is an independent medical examination. I laugh when I say that because it's anything but. IME physicians are insurance company doctors who oftentimes, I find, receive 6 figures annually to do nothing but see you for 10 minutes at the will of the insurance company and terminate your benefits. We all know who they are, and you out there know who they are as well. These docs have also been given more power by the insurance company to cut your benefits off faster and more arbitrarily. And what is that? If you miss 2 IME appointments, it's considered, there's a presumption that your refusal to submit was unreasonable. How does that happen? Well, they fax your lawyer the notice for the next day at midnight, and you can't show because you have to work. They can do that 2 times, and you never know, and boom, they don't owe you anything further. In the court case that we subsequently then file, we have to prove that your refusal was somehow unreasonable. But what a presumption is in the legal world, it's like going up to play baseball with 2 strikes against you. Not a very good chance you're going to hit the ball. That's what the legislature is doing to consumers and doctors in this state. Doctors, if you hear the words EUO or IME, tell your patients to call their attorney and get instruction and comply. And consumers and patients, listen to your lawyers. Follow their instructions thoroughly. And if you don't have one, you should get one as soon as you can, so you avoid these huge potholes in your clinic.